Well, good evening, everybody. I'm Corey Pedersen, President of Stratawest Management, and on behalf of my business partner, Jason Kurtz, and our colleagues at Stratawest, I'd like to welcome you this evening and thank you for joining us. As noted on the invitation that we sent out to you, we have two very good speakers this evening. Shannon, Chair of the Civil Resolution Tribunal, and Tony Gioventu, Executive Director of the Condominium Homeowners Association, more commonly referred to as CHOA. I'm just going to have a few brief comments and then I'll get out of the way. These are two very good speakers and I don't want to give you too large of a sample size to compare against. Thank you. I have final edit evidently and we'll be able to inject any applause necessary. We'll of course be discussing the Civil Resolution Tribunal, how it works, how it is working, and there'll be an opportunity to ask questions on that. Towards the end of the presentation, Shannon will go first and then Tony will follow. Just a couple of items to take care of before we get going. One, I've heard a couple of cell phones turn off, so thank you. Please turn your cell phones off or turn them to vibrate. Also, you could ignore the camera. We're filming tonight a reality show called Strata Survivor. We're gonna get together 80 to 100 of our best clients and see how long it takes for us to start talking about pets or parking or something. Unfortunately, you get voted off of your Strata Council, so try to keep on topic. The presentation materials, a couple of people have asked. Tony has printed off some of his presentation, but we'll be combining the presentation materials for this evening and providing them to you later this week, probably. I say probably because I sit on the board of SPA BC, and we're currently working on a document with Hammerberg lawyers that is coincidentally titled Civil Resolution Tribunal brochure, educational brochure for Strata Councils. So it seems incredibly pertinent to send that out to you folks as well. So once that is ready, we will cobble together the information and we'll provide it to you. It will also be on the blog at stratawest.com. I know many of you visit that from time to time. We have a fairly impressive readership actually. There's blogs on there usually monthly, sometimes multiple times a month. They are on recent case law, new case law, potential revisions to the Strata Property Act, items that are making it into the media, and things that individuals like yourselves ask us to write about. So we're always interested in topics. Often we'll do a little Strata Property 101 type of thing to talk about a nuance or something to do with the Act that just helps the Strata Councils better guide their strata corporations. The continuing education and guidance is a very important thing for us. So we thank you very much for taking part in this and in visiting our blog. You can ask your property manager to be advised when a new blog post goes up. And again, we actually had a seminar similar to this one on depreciation reports, and I think it's up around 8,000 or 9,000 views. We did that was with Pat Williams from Clark Wilson and David Albright from RDH. We don't use any Google wizardry on our website. Whoever goes there, and so the hits are actual hits. We do appreciate the feedback and suggestion for topics. I don't want to digress onto anything. It's very difficult when you have this many clients in a room not to talk about all manner of things, but I would definitely be remiss if I didn't take the opportunity to thank you for your business. It's obviously extremely important to us, and we are going to be celebrating 25 years as a company in the next couple of months. Jason and I took ownership 6 years ago, and the transition was very successful. Our relationship is a big part of that. The openness of that and the mutual respect that we have between property managers, the bookkeeping staff, administration, and you as Strata Council members is intrinsic to our ongoing business. And we have clients in here who have joined us over the last 6 years. We have clients who've been with us for 18, 19 plus years, and that type of retention is fairly uncommon. We really do try to attract the very best people in all aspects of our company, and we try and retain them by treating them well. And that provides continuity of service for you folks, and it is a very good equation for us. So thank you very much indeed for your business. It's much appreciated. And now to introduce our speakers. We're very, very pleased to have these two individuals. They've both flown in today, which is tremendous, and I thank you for that and your, the schedules that these two keep are absolutely unbelievable. But in any event, Shannon Salter, she has been actively involved in pro bono legal advice and representation from early in her career. Her very impressive CV is a straight line, seemingly, to her appointment as the CRT chair in 2014. And since then, she has been a part of the evolution of the CRT and all aspects of its development, and is a very impressive individual, and you will find that out in a moment. And Tony Gioventu, many of you will know him through his writings in the Province and Sun. He has been the executive director for CHOA forever, many, many years, representing the interests of strata property owners, providing guidance and support, resources, and he is omnipresent in our industry. His writing is extremely prolific, and in fact, I'm sorry, Tony, but it's propping up the projector right now. One of my staff member brought me an article on the CRT written by Tony in September. I usually catch all of them. It was in a publication of a magazine I've never seen before, so as the publishing industry and newspapers are dying out, someone is literally creating new magazines for Tony's writings to appear in, so it's rather impressive. In any event, that's probably enough out of me. Please join me in welcoming our first speaker, Shannon Salter.
Thank you very much, Corey. Thank you very much to Corey for inviting me today, and thank you to all of you for showing up on a drizzly Tuesday evening. I appreciate it. I always really enjoy speaking directly to strata councils and strata owners because I know you have a lot of questions, and I know that you live directly with the outcome of what the CRT will be. And so this little experiment of ours, which we hope will be a new way to deliver justice services in BC, really starts with you. And the strata community has been extraordinarily patient with us and very supportive and generous with feedback as well. So thank you on behalf of my team. So my object tonight is to tell you a little bit about what the CRT is. You no doubt have heard bits and pieces over time, but we are actually operational now. So it's an opportunity to tell you how it's working, and also hopefully to answer your questions about what that means for you as strata council members and what it means for your strata corporations. Have any of you attended a talk on the CRT before, either by me or somebody else? Fresh crowd. I only see 2 or 3 of you, so that's great. So what is the CRT? Well, it's part of the justice system. That's one thing to know. So it's an administrative tribunal, much like the Human Rights Tribunal or the Workers' Compensation Appeal Tribunal or any of the other 27 tribunals there are in British Columbia. So administrative tribunals are part of the justice system because what they produce are orders, and those orders are generally enforceable by the court. They also adjudicate people's rights and obligations and responsibilities, just as the Civil Resolution Tribunal will do. It's the first online tribunal in Canada, and actually one of the only ones we know about in the world. And so as a result of that, we're getting a lot of international attention, which we try not to let pressure us too much. So for example, Lord Justice Briggs from the United Kingdom paid a visit to us in May because the United Kingdom is setting up Her Majesty's Online Court. They're actually planning to call it that, Her Majesty's Online Court. So we tried to share as much information as we could. Corey mentioned that fresh off a flight, so I'll blame any misspoken words on jet lag, but just spent the last week in Australia because the government of Victoria in Australia brought me down there for a week to share with them our experience. They're also hoping to do what we're doing with the CRT with what they call owners corporations, which is their version of a strata. All to say, we get a lot of attention for being online, but I actually think that the technology part of the tribunal is secondary. Really, the goal of the tribunal is to build this area of the justice system around the public. And how do you do that when you live in a place like British Columbia where people are busy with jobs and work and community obligations and children and sometimes live in far-flung areas? Well, you use technology as a tool where it makes sense to connect people. So really the CRT is a very human-driven process. It's about giving people the support that they need to resolve these disputes in what we know are little neighborhoods, little communities. And I think that hopefully will strengthen your communities and also strengthen our society generally is our goal. So what kinds of things can you bring to the CRT? Well, the CRT has 2 main buckets of jurisdiction. The one that we have jurisdiction over now is strata property disputes, and in a few months, in early 2017, we'll also have jurisdiction over low-level small claims as well. So I'll get to those in a moment. Tony is going to do a bit of a deep dive for you on the intricacies of our strata jurisdiction, but this is just to give you a bit of an overview. Basically, we can adjudicate and help resolve the wide majority of everyday bread and butter disputes that arise in your communities. So issues to do with fees and fines, unfair actions by the Strata Council or a majority of owners, interpreting the legislation, the regulation, the bylaws, problems with governance like AGMs, voting, proxies, and issues with respect to repairs and common property. We also have a very wide ability to make orders. So we can order someone to do or stop doing something or to pay money. And that goes a fairly far way in resolving disputes. There are some things that we can't do. And Tony's going to cover all of this in a bit more detail, but generally we can't order, for instance, that a strata corporation be liquidated. We also can't order that an administrator be appointed. Anything that involves the underlying interest in land, you still need to go to the BC Supreme Court for. But before July 13th of this year, about 4 months ago, you had to go to the BC Supreme Court for almost all of this, which is expensive and time-consuming and difficult, as any of you know who have contemplated such a thing. Strata Council experts, lawyers, tell us that for their clients, on average, taking a claim like one of these things to the BC Supreme Court costs their clients between $25,000 and $35,000, just in their own legal fees. Now, that doesn't include court fees, it doesn't include the other side's legal costs if you're unsuccessful, and it also doesn't include the time and energy and effort that takes. So we're hoping to offer a much more accessible way to resolve these disputes. So that's strata. I'll touch lightly on small claims. I know that's not our focus tonight, but there is a bit of overlap sometimes in the kinds of disputes that you might see. So small claims are very, very broad. The only thing they really have in common is a monetary threshold that's low. In BC, the monetary threshold is $25,000. So claims under $25,000 can go to the BC Small Claims Court right now. Early next year, you'll be able to bring low value small claims to the CRT instead. So these are claims involving things like debt or damages, recovery of personal property, low-level personal injury claims, things like nuisance claims, contract issues, and also specific performance of agreements. Again, the tribunal can't deal with matters that affect underlying interests in land, so you can't recover real property in the CRT. Some quick points, though, about the strata jurisdiction. These are questions we get asked pretty often. One is that there is no monetary limit for strata claims. So while there is a limit for small claims that can go to the CRT, there is no limit for the value of a strata dispute that can come to the CRT as long as it's otherwise within our jurisdiction. So for instance, you can have an insurance deductible for $50,000 and that can come to the CRT. You can have an envelope repair for common property that is $500,000 and that can come to the CRT. There is no monetary limit. In terms of bylaws and rules, we can deal with a lot of different issues with respect to those things. We can address issues about whether they are enforced fairly and properly, whether the bylaws and rules are consistent with the legislation. And an example there is election signage bylaws, for instance, that might otherwise violate the Act. Third, unlike with initiating a court case, you don't need to have a 3/4 majority vote of the owners in order to start a CRT claim. The Strata Council can start a claim itself as long as it has a majority vote of the Strata Council. So you don't need to go to the owners to authorize a CRT action. Much like with the Small Claims Court, there is limited cost recovery. So the downside to the owners of an unsuccessful CRT action is pretty limited in terms of costs. You won't, you're likely not to have to pay the other side's legal costs. For one reason, lawyers are generally not part of the process, but also just like Small Claims Court, lawyers' fees are typically not recoverable in the CRT process. And then last but not least, this wide authority that the CRT has to make orders can cover all kinds of issues. So things like hardship applications, ordering the payment of fees or fines, ordering somebody to comply with the bylaws, or declaring, for example, that a bylaw is unenforceable because it is inconsistent with the Act, or ordering that a strata corporation convene a meeting. These are all types of things that the CRT can order as remedies. So that's a little bit about what our authority is, but where does this authority come from? Well, it comes from the Civil Resolution Tribunal Act, which was passed in 2012. And originally, this was meant to be a voluntary scheme. The idea being that it would be mandatory for strata corporations to participate, but owners would be able to choose whether to participate or not. Not surprisingly, we heard from a lot of stakeholders like you that that was not going to work very well for them, and that unless everybody had to participate, there wasn't a very high chance of success for this project. That's also supported by other pilot projects involving online dispute resolution in BC. And so in 2015, the legislature passed amendments to the Act to make the CRT mandatory for strata property claims for everybody, and also to make it mandatory for small claims within a certain monetary threshold. So that means that as of July 13th of this year, all strata property claims within the CRT's jurisdiction have to go to the CRT. They can't go to the BC Supreme Court instead. Now, if somebody doesn't want to go to the CRT, they can ask for an exemption and go to the court instead, but I can tell you we've received no applications for an exemption so far. It is early days though. If somebody doesn't like a decision from the CRT, we're not the last word. Just like any other administrative tribunal, there are appeal rights. So those appeal rights look different depending on whether you have a small claim or a strata claim. But if you have a strata claim, your appeal lies with the BC Supreme Court. But it's a pretty narrow right of appeal. And that's because you have to get what's called leave or permission from the court to be able to appeal. So if you don't like the result of a CRT claim, you first have to go to the BC Supreme Court and ask for permission to appeal. The court will consider whether to give you permission to appeal, and if they say yes, then you can appeal, but only on a question of law, not on a question of fact. So it has to be about whether the CRT got the law wrong. So the result from all of this, I think, is going to be that there's probably a pretty high degree of finality from CRT decisions. And that's consistent with what folks like you have told us as well, which is that you don't want to go through a CRT process almost inevitably to have to go to the BC Supreme Court anyway. So that's a bit about the CRT, but a question I get asked a lot of the time is why the CRT? Why start an online tribunal instead of, for example, just folding strata complaints into the existing small claims court? And I think really the answer to that relates to access to justice, which I think most of you would know is a big problem in Canada. It's also a big problem pretty much everywhere you go in the world, so it's not unique to BC. But in our little corner of the world, that access problem is still pretty acute. So it means that for people who live outside of the Lower Mainland, it can be actually very, very difficult to access a courthouse or to find a lawyer. Meanwhile, as a percentage of residential housing stock, strata property never really dips below 25 or 30%, no matter where you go in the province, even if you go up north. So we sometimes think about strata as an urban issue, but really it's the most common property ownership type in British Columbia. And half our population either owns a strata, lives in a strata, or rents a strata. So it affects a lot of people. I don't have to tell you that it's a complex area. You deal with that every day. And there's no legal aid for these kinds of claims. You have to go and hire a lawyer if you need help. In the small claims court right now, it takes almost a year to get a trial. There are similar delays in the Supreme Court, and there are backlogs in both levels of court. It can cost a lot. I mentioned the travel costs, but even for people who live in urban areas, you have to take time off work, arrange childcare if you've got kids, just to get to the courthouse. I've talked about the legal fees as well. So it's not surprising when you look at this that out of every 100 cases that are filed in our civil courts, only 2 actually get to this end stage where they have a trial. 2. So that means 98 out of those 100 cases don't get to trial. And lawyers like me tell themselves a lot that those cases just settle, so that's okay, everything works out. But new research is showing that that's not true. About half of that 98% of cases don't settle. People just give up. They just run out of time and money. But their underlying dispute doesn't go away. It just simmers. And we see that a lot with strata. I've heard from many, many hundreds of people that they cannot take their case to court. It's too expensive, but there's no accessible way to resolve their dispute. And so they just live with it for years. So what are we doing to make that better? Well, we have a blank slate with the CRT. And so we've really taken advantage of that to try and figure out what it is that people want, what's going to work best for them, and pioneer a new way where we bring the justice system to people, we build it around their lives, we constantly ask them if we're doing a good job of that, and we are constantly trying to improve. This is in contrast to a justice system that was really built around lawyers and judges and not people without a legal background. And so it can be very confusing actually for people without a legal background to figure out what the steps are to take, how to fill out all the forms, what language to use, never mind stressful as well. So one of the first things that we did was did a survey of British Columbians. And so this survey was conducted by BC Stats, which is the BC equivalent of StatsCan. And what we found is that 92% of people in BC use the internet every day. And this was weighted by age and geography, education level. And unless you thought we were being cute and asking people on the computer if they use the computer, this was actually a landline-based survey. So we're not that cheeky. So 92% of people use the internet every day, but about 3 to 5% of people don't use it at all. And we have to keep an eye on those folks as well and make sure that we have ways for them to participate. But overwhelmingly, we're comfortable in BC with things like online banking. 80% of us do online banking. We're comfortable with texting, emailing, social media, shopping online, basic activities like that. We also asked people what they were looking for when they're having a civil justice problem. And not surprisingly, people overwhelmingly said that they wanted to participate in resolving the dispute themselves. So 82% wanted to be able to negotiate with the other side. 94% didn't want a judge or tribunal member like me just telling them what the outcome was going to be. And 87% of people didn't want to use a lawyer for the whole thing, probably because of cost, I imagine, although we didn't dig too much into that. 81% of people said they would use an online civil justice process that was user-friendly and available 24/7. And going back to this slide, one of the statistics that surprised some of the younger people that I work with and some of the younger lawyers that I talk to a lot of the time is that 69% of people over the age of 74 also use the internet every day in BC. So I tend not to actually get that question from older people, but younger people tell me all the time how older people cannot use technology. And I don't know where that comes from, but it's not backed up in the statistics. And I think I've found the hard way that if you make that assumption in a room full of older people, you get a lot of glares because people are using technology by and large. And the digital divide is very much closing. Now, that's not to say that we should be expecting people to learn how to code or do complicated things. But if we design technology that people are already basically using, then that's bound to be a lot more understandable than the existing justice system is for them. Okay. So we took some of that research, but we also did a lot of other research. So we did focus groups. We have a Strata working group with Strata representatives from your community. I've done a ton of public forums with the help of CHOA and other stakeholders, and we've talked to thousands of people. And we've listened pretty closely to what they had to say. So what they've told us, and this is also backed up by research, is that the key is having a process that people can get through quickly. That the longer somebody has a civil justice claim, the worse it is for them. And there's some research that shows that the longer somebody has a claim like this, the more their physical, mental, and financial health suffers. On average, people have one extra doctor's visit a year, for example, if they have a civil justice claim on the go in Canada. About 40% of people can attribute a specific ailment to their civil justice claim. So whether or not that's correct or not, they certainly have the impression that it's not good for their health, and they're probably right. So if we can get people through the process in 60 to 90 days, we think that's good for them, and that's what we're aiming to do. Part of the way to do that, though, is focusing on early dispute resolution. So offering people a lot of choices about how to resolve their dispute. We give people every opportunity to help resolve it themselves before we impose an adjudicative decision. That's there as a last resort. but we're also really focused on continuous improvement ourselves. So one of the dangers of a project like this is that we can get really attached to this new way of doing things. And we can become almost as dogmatic about that as some people are about our existing justice system. So continuous improvement through user testing, for example, keeps us really humble, because we've learned that the public, that you, will not hesitate to tell us if we've got something wrong. So it's important to keep checking back. In terms of access, the CRT is available 24/7, 7 days a week, anywhere in the province where you have an internet connection. The front end of it is free. And anonymous. You don't need to have a CRT claim to use it, and we'll show you what that looks like in a moment. Turns out, not surprisingly so far, that about 40% of people are filing their claims outside of business hours. So outside of the 9 to 5 hours that you could use a court registry, for example. In terms of cost, the CRT costs roughly what the small claims court costs now. So it's $125 to file your application. That takes you through the mediation phase. And then if your claim has to go to adjudication, it's another $100. And that came from fee surveys that we did, where people expressed a strong preference for paying fees in stages. They also expressed a strong preference for discounts for doing things online, as well as having fees at all. There was a strong feeling that if you didn't have fees, that strata councils, for example, would be inundated by claims, that you need to have some kind of a deterrent. At the same time, though, we know not everybody can afford to pay fees, and so we have a very generous fee exemption process if somebody is on a fixed low income. Okay, last but not least, how are we going to meet this 60 to 90 day timeline? Well, we're doing it through active case management, really aggressively having clear timelines, having people stick to the timelines, and focusing as much as possible on early dispute resolution. So those are the principles, and those drive really everything that we do. But here's how it actually works. There are 4 stages. The first stage is something called the Solution Explorer, and I'll show you that in a moment. That is live online now, and it offers free legal information on strata issues. There are streams for strata councils, like you folks. There's also streams for owners and tenants. So the content is directed differently depending on who you are, trying to target the content to people's need. If that doesn't help you resolve your dispute, you can start a CRT claim from the Solution Explorer. You'll have a brief opportunity to negotiate with the other side, but that candidly doesn't resolve a lot of disputes. If people were able to do that, they would have done it by now. And so it's really this third box where we connect the parties with the facilitator, where we expect most of the resolutions to happen. And then there's adjudication there as a last resort. That's where a tribunal member makes a binding decision that's also an enforceable court order. But you can see we're flipping the traditional justice system model. Instead of assuming that everything will go to trial, when we know most claims won't, we focus most of our resources on early consensual dispute resolution. Also recognizing that you live in little neighborhoods, and that win or lose, people are going to still have to see each other at the mailbox or in the common rooms. And so if they can work out an agreement consensually, that's better for your communities, is what we've heard loud and clear. So what communication methods can you use? Well, you'll see that we offer mail and telephone-based services at each stage, although in the 4 months that we've been operational, we've had very, very few requests to use mail-based services. Overwhelmingly, people seem to prefer email. So that's good. Okay, so the first phase is the Solution Explorer. And this comes from research that shows us that it's pretty useless to give people who have a strata problem or any other kind of legal problem a 40-page PDF on their area of the law. Because people with a strata problem don't want necessarily to become strata experts. They just want to know if they can keep their chihuahua in their unit. And that's a pretty specific problem. So we can give people information about that specific problem if we ask them questions first. So that's all this does. It's an interactive question and answer platform. And it comes from expert information, expert knowledge that we got from strata experts. So Tony, for example, volunteered over 1,000 hours of his time to be interviewed so that we could put all of what's in his massive cranium into this software system. And I don't think we've got quite all of it, but we hope to have content to cover at least 80% of the most common strata problems. So we've sat down with people like Tony and strata lawyers like Pat Williams, and from that have made plain language targeted pieces of legal information that we hope will be useful to people. So what does this do? Well, it helps them diagnose their problem. It also helps them realize where there are strengths and weaknesses to their claim. And oftentimes, it used to be that you would see a lawyer for this. So you'd sit down with a lawyer, the lawyer would say, okay, Bob, here are some strengths for your claim, here are some of the weaknesses, here are the risks of going to court, here's how much it will cost you. And now people don't do that so much because they can't afford lawyers. And so oftentimes, the first time they might realize that there's a weakness is when they're on the losing end of a judgment, if they're part of that 2%, or along the way they just realize that through documents they've had or some piece of information they've come to. So we're hoping that by telling people that information up front, they can make better choices along the way. We're also giving them tools to resolve the dispute themselves. And one of those tools that you're likely to see a fair bit is something called a template letter. And I'll show you what that looks like in a moment. So this is the result of about 7 or 8 rounds of user testing. And so far, it seems to be working pretty well. In the last 4 months, we've had 2,600 people go through the Solution Explorer. By contrast, we've only had 130 cases started. So it looks like, and we're verifying this through analysis, but anecdotally, it looks like people are getting largely the information they need from the Solution Explorer, and they're using some of the tools to try and request a hearing from their strata council or to talk to that neighbor and try and work out the problem themselves. So one last thing to point out is that the CRT works just as well on a tablet like this, on a cell phone, or on a desktop. And that's because rapidly cell phone technology, smartphone technology, is becoming the most common technology that people have in their home. So our poverty advocates who we consult with tell us that for their low-income clients, they may not have any other piece of technology in their home, but they will almost certainly have a smartphone and know where to access data. And so we've designed it to work seamlessly on a smartphone. You don't need any kind of an app or anything like that. So this is the CRT website. And if you wanted to use the Solution Explorer, you would start with the Getting Started button. And that would take you to a page that would allow you to select solutions for strata councils or solutions for owners or tenants. And if you have a smartphone with you, you're welcome to follow along. What I'm showing you are screenshots that are very truncated. So I'm going forward a few screens at a time just to show you the features. And also so I don't suck up all of Tony's time because it would take a lot longer. But this is up and running, so please feel free to explore it and let us know what you think. So what does it do? Well, it asks you questions. So imagine you have a rental issue. You're an owner with a rental issue, and the strata won't give you permission to rent your unit. Well, your issue would fall under the 3rd bullet point there. The strata won't give me permission for something. And this font is very small, so I don't expect you to try and read this. Again, you can follow along on your phone if you'd like. But just to get the idea of what it looks like questions and answers. And if somebody's question is not, or issue isn't there, they can click this button at the bottom and tell us what's missing. And that's been really useful for us because it lets us know where we need to add content in the future. There's a progress bar here. We found from user testing that people like to know what they're in for, how long something's going to take them. And there's an access code. So if you need to stop and make dinner or go to work, you can pick up where you left off. We don't collect any personal information at this point beyond just aggregate user information. So you don't need to provide an email or log on at this point, but this access code does let you pick up where you left off. There's a help button, so you can ask us a question, and you can also tell us if there's any problems with the technology. So lots of ways that we're collecting feedback from people. So we ask some questions, and then we give you plain language legal information. This is about a page and a bit on renting your strata lot, including some of the common exemptions that are found in bylaws. So somebody can rate this resource by clicking a button and giving us a star rating. They can also hit this very cathartic not helpful button if they don't like it. And that's good for us because it lets us know if this is a dud, we know on a weekly basis. We review all of these statistics weekly, and we know we have to address issues. And we do that as they come up. We don't wait for a yearly review. So we give people information, we ask questions, and as we show them information like those resources on renting your strata lot, they pile up on the left-hand side. And this came from user testing that showed us that shockingly, people who have problems don't think like a room full of lawyers and IT professionals. That was news to to me and all the IT professionals. So lawyers and IT professionals tend to think in a very linear way. If A, then B. Well, if you have B problem, then you will find solution C. And when we did a form of testing called observational testing, where we invited people with strata problems to come, sit in front of a computer and just use the system, and we recorded them with their permission, what we found was that people like to rush in and they'll just click through everything until they find what they consider to be the most useful bit of information. And then they'll slow down and jump around. So we made it a lot easier for people to do that. We used to have very paternalistic little warnings like, are you sure you want to change your exploration? You're changing your direction now. And so we got rid of all of that. Short story there is that user testing has been very, very helpful for us. And now whenever we're in a room and we hear either lawyers or IT people saying, well, I think that the public will do this, or I think the public will do that, that's a big warning sign that we have to go back and user test, because we're usually wrong if we try and make assumptions like that. Okay, so here is a form of the letter that you're likely to see. This is a very popular resource in the Solution Explorer. It's a template letter that's already filled out, and it's based on the information people have told us at this point. At this point, this person's told us they have a bylaw rental issue, and they might fit into one of the exemptions in the bylaws. And so they're requesting a hearing with their strata council. It already has the relevant part of the act. It already has the timelines, the fact that you have to hold that hearing within 4 weeks. And it's already written for them. All they have to do is enter in their own information. They can edit it on their computer. They don't need any special software. And they can print it or email it or download it so that they can send it to their strata council. At the end of their exploration, they get this summary report, which just summarizes everything that we've told them. And at this point, it looks like people are stopping, using the resources, sending those letters, requesting the hearing, and largely resolving their dispute wherever they can. But you can also scroll down at this page and start your CRT application right from this page. So something we get asked a lot is, well, where's the application form for the CRT? Where is it? Well, we do force everybody to go through the Solution Explorer. We want people who are well informed and knowledgeable about their claim before they're coming to the CRT. The other reason we do that is that it is a requirement to request a hearing before the Strata Council before an owner can come to the CRT. So they have to go to you first and have their hearing. Sorry, they don't have to have the hearing, they have to request the hearing. They don't have any control over when or if that is scheduled. So if they don't do that, then we will go back to them and say, have you had the hearing yet? What was the outcome of the hearing? So it's another reason that they should go through the Solution Explorer first. So once they've gone through the Solution Explorer, clicked that green button that I didn't show you, but is at the bottom of the page. If you're looking for the application form, it's at the bottom of the summary dispute page. They're taken into the application form, the online application form. And at this point, we do start collecting personal information. And we do know that they're coming as an owner from the Solution Explorer, so we give them the page for an owner rather than the page for a Strata Council. If you use the Solution Explorer as a Strata Council, you'd get the Strata Council page. So we try to make it less confusing in terms of figuring out which form to use. How did we design this form? Well, we started in a way that's really unusual in the justice system. We cobbled together as many community advocates as we could, people who serve very vulnerable, barriered people, clients, and we walked through all the conceptual designs with them. And then we made a whole bunch of changes based on their feedback. Then we recruited people who had had past strata disputes and small claims disputes, members of the public. We asked them to fill it out. And then we asked them what we got wrong or what we were missing or what we should have asked about. And then we made a whole pile of changes. And so what you're seeing is really the result of a co-design process with the public. And normally the way that court forms are, or tribunal forms are designed, and any of you have had to fill those out will know this firsthand, is that court administrators design those forms and they don't user test them, which leads to a lot of confusion for people about how to fill them out, including a lot of lawyers. Lawyers get stuff bounced from court registries all the time. So if lawyers can't figure out how to fill it out, it's pretty difficult for somebody, for example, who doesn't speak English as a first language or who might have literacy issues. So we've designed this as easily as we can. And I should say, too, that plain language is a key value that we have. So the Solution Explorer is all written, hopefully, ideally, at a grade 6 level. That's what we aim for, because that's what people tell us, experts tell us, you have to write at if you're creating information for the general public. And it doesn't matter if it's health information or legal information. So that's what we try and do, and our decisions will also be plain language. So we're asking some pretty basic information here. We let you know where you are in the process on the left-hand side. I'm just going to highlight some things that we do a bit differently from other forms you might see. One is that we ask people information about how we can accommodate their needs better. We may not be able to do that all the time, but we at least ask so that we can try. This is information that doesn't go to the respondent, it's just for the tribunal, but we ask people, for instance, if they have difficulty speaking English, reading or writing, if they have a visual or hearing impairment. And sometimes people who have those kinds of needs may not be filling out this form themselves, but a friend or family member might be doing it. So for instance, if somebody indicates they have a visual impairment, one of our resolution support clerks will call them and ask them what supports they have in place and whether they would prefer to communicate through telephone. So we do our best to try and accommodate those needs where we can. The other thing that we ask that's a bit different is, what have you done to try and resolve this dispute so far? So we really want people to take ownership of their dispute, to try and do what they can to resolve it. But this information also helps our facilitator know where the dispute is at. We also ask, why is resolving this claim important to you? Again, we're trying to get at what people's interests are, rather than just what their strict legal positions are, with the hope that this will help people reach consensual agreements a bit better. So those are some snapshots from our intake form. This is a bit of a snapshot of our most recent user testing. It's probably the 7th or 8th round of user testing. It was about a 3-week period in the summer. So we keep changing, making changes, and then user test again. And I'm really just showing it, I guess, to demonstrate that I think user testing works well. It's not done very often in the justice system, but the more you can polish off the rough edges of a technology, the more acceptable I think it will be to people. So 88% of people told us the technology worked well. 95% of people said it was easy to use. So that's a really good sign going forward. And we'll continue to do that. Okay, so what happens when you've gone through the intake form, the intake process? Well, you click submit. The CRT reviews the intake form and gives you back a dispute notice. It's your responsibility, if you're the applicant, to serve that dispute notice on the respondent, so the other people in the dispute. You can do that in a variety of ways. You can try to do it by email, and if the person responds, that's good enough. If they don't respond, though, then you still have to serve them either through personal service or registered mail. And there's information about that on the form. Once that comes back to us, the parties have a brief opportunity to negotiate, but really most cases seem to be settling in facilitation. So in facilitation, we have dedicated facilitators who are dispute resolution experts, people with mediation training, and they work with the parties using whatever communication method works best for them. So if you're somebody who's not very comfortable with technology, for example, it's likely the facilitator will organize a telephone call, conference call, or a video conference call, rather than going back and forth by email. So they use their judgment to make that determination, and they work with the parties to resolve either some or all of the disputes. And everything that happens in this phase is confidential. It doesn't get told to the tribunal member if the case has to go to adjudication. So what is the outcome of that? Well, if there's an agreement, this can be turned into a tribunal order. The benefit of that is that it's enforceable as a court order. Whereas if you're in private mediation and you reach an agreement, what you have is a contract, but you don't have an enforceable court order. So you would still have to go to court and sue on the contract if somebody broke it. Whereas with an enforceable court order, you can go to court to enforce that order. If there's no agreement, then the role of the facilitator is to help prepare the parties to get ready for the hearing. And the hearing is where a tribunal member will decide the dispute. Again, their decision is an enforceable court order. So last but not least, adjudication. Again, this is where we hope only about 10% of claims will be resolved, but we'll see how that goes. We have 16 part-time tribunal members, half of whom are specialists in strata law. They're all lawyers. And we also have 2 full-time members. I'm one of them, and then Garth Cambry, who many of you might know, or some of you might know, is a full-time vice chair of strata, and he's a strata expert as well. Our hearings are largely through written materials, unless there is a reason to have an oral hearing, like there's credibility issues or it's just too complicated to decide based on written material. If that's the case, then an oral hearing will be held through video conferencing and telephone conferencing. The tribunal members have been through a boot camp because they are all senior lawyers. There's a bunch of QCs among them, and they are not used to writing in plain language. They are used to writing in $10 words because that's how lawyers are used to writing. And so it's taken a bit of a boot camp to get them their mind turned around to writing in plain language, in brief decisions that are really directed at the parties so that the parties understand why the decision is made. So they've had a ton of training in this and in a whole pile of other issues as well. And our decisions are going to be published on the website, but also in a really robust, searchable search engine so that it's easy to find. I've talked a lot about continuous improvement, only just to say that even though we're still operational, we are trying to improve every day. So we have weekly meetings to go over public feedback. We incorporate that wherever we can. So if you have any issues with using the CRT, please send us an email. We read and respond to every single one, and they go straight to us for review as well. And I think with that, I'll just leave you with my information. I hope I haven't taken up too much time. I'll hand it over to Tony. And I think there'll be time for questions at the end. So thank you very much for your attention, and I look forward to hearing your feedback.